And we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. For we are opposed around the world by a monolithic and ruthless conspiracy that relies primarily on covert means for expanding its sphere of influence.
It was 1776 when the founders signed the writ of independence from the Brits. It was revolution.
Well, thank you, folks, for joining us for another program on the Connecting the Dots radio show with Dan Happel. I really appreciate people being here for this one. Our guests today are, again, Elaine Wellman and Lawrence Cogan. They are both very, very actively involved in the, let's say, expose of Senate Bill number 2012. It's the Mikulski bill. And it happens to be a so-called North American Security and Infrastructure Act bill. In other words, supposed to be an energy bill. And it has a lot of very dangerous language within the bill that was kind of slipped in under the guise of being an energy bill, but in fact it really has a lot of pertinence to the Indigenous Peoples Treaty, to the water and forestry bills that have been associated with the reservation lands. And with that, I'd like to turn the program over to Elaine and Larry and let you folks kind of explain how this bill came about and what you're concerned with.
Well, Dan, thank you for having me on. This is such a critical time across the country. And Larry has the particulars and some details that I will defer to him to, but I wanted to just kind of do a little intro on why this bill is so significant for several reasons. But a little background first. Your listeners need to understand that that tribal governments do not make decisions regarding federal Indian policy. Tribal governments certainly financially and politically influence these decisions, but they do not make them. All of federal Indian policy are decisions made by Congress or the executive branch or the courts or governors and state legislators. They are made by, all of federal Indian policy is made by people we elect. And that is the profound concern of this Energy Act of 2012. So our conversation, and I would sure encourage every listener to get on the phone with their senators, congressmen, governors, and folks that might be able to help us with this. This is a major act that ordinarily is put together by the Department of Interior and the USDA, Agriculture. Ordinarily, something of this magnitude would have involved regional public hearings around the country, taking in public input, full NEPA, National Environmental Policy Act review. It would have involved a lot of public input, a lot of environmental analysis before they even got to the bill. All of that has been completely ignored. What was not ignored was tribal consultation. The senators and congressmen all reached out and consulted dutifully with the tribal governments. And their support and their requests are fully addressed. The public is absolutely ignored and ignorant of what's in this bill. It is, for your listeners, Senate Bill 2012, sponsored by Senator Murkowski. If you go to congress.gov and you search S2012 Energy, the bill will come up. And if you save it as a document, a PDF searchable document, you can find the big and most dangerous chunks in the bill, even though it's 792 pages with 363 amendments. So what I'm going to do before Larry gets into the real political impact and environmental and constitutional impact, what I'm going to do is just highlight a couple of pieces in the bill. The big piece is Title VII, Roman numeral 7, the Tribal Forestry Participation and Protection Act that starts on page 333, 333 through 338. That's the Tribal Forestry Participation and Protection Act. That's the guts of the harm. And then there's also Title IV, the Native American Energy Act is incorporated in this. In Title 26, these are Roman numerals, Title XXV1, Western Oregon. This is really critical for the Oregon folks, and Larry has expertise in that area. The Western Oregon Tribal Forestry Act, which conveys a ton of land in Western Oregon, not just gives them management, conveys land. And then there's streamlining to make it very easy for these tribes. It's put on by the Bureau of Reclamation at page 459. This act conveys and transfers and incentivizes tribal governments, 567 of them, to go after and manage our American national forests. It conveys to 2% of our population control of our national forests to the direct impact and harm of 98% of the American public. It has specific impact on hunting. There's a section in there on hunting that is very concerning, where the management will include management of hunting. And beyond that, it just troubles me. I'm going to turn the rest of the conversation over to Larry, but it just troubles me that in years gone by, really major must-pass acts, and this one has to pass by the end of the year, it's a major appropriation bill, are involve engagement with the public, input from the public, or at least posting in the Federal Register and public comment, something. This has involved nothing, and this has been intentionally hidden by this Tribal Forestry Management Act provision. It used to be freestanding bills, which Larry will tell you about, but now it's been tucked into this big Energy Act to avoid any further confrontation by people who've been raising their concerns about it. But we found it in this act, and we want the public to know just how serious and dangerous it is. It's also kind of the best example I can think of why the American public is so distrustful of Congress, and why Congress seems to have stopped listening to the people that elected them. And it just troubles me very, very deeply when we're coming up on a major election that can either change the course of Congress or put us in dire straits for probably generations. So with that background, I'll hand it over to you, Larry, because you've really done some intensive research on this. Thanks.
Well, I don't know if I can, step into those shoes, Elaine. They're quite large, but nevertheless, what we're talking here about is not merely allowing federally recognized Indian tribes or any Indian community providing them with the ability to help prevent forest fires on national lands from encroaching and destroying Indian reservations or other Indian lands that are held by tribes or individual Indians. We're not talking just about what they refer to as borderlands or even adjacent sites to national forests and parklands, but we are talking about national lands, both in forest and out in the prairie, that could potentially impact not just reservation, but treaty lands. And when you start getting into that nebulous term of treaty lands, you start to realize that there's more here than what is being expressed in words. Treaty rights, depending upon what tribe was a party to that treaty with the United States way back when, could include both reservation-focused rights and off-reservation-focused rights, on and off. And what this tribal forest management legislation would allow the tribes to do is to invoke those off-reservation rights. There's approximately 60 tribes in the Pacific Northwest, Northwest, and Northern Rockies that have treaties with the United States that allow them to exercise rights off the reservations. They ceded lands that were once that they once lived on in exchange for peace and a reservation with the United States government. But in some of these treaties, they reserved and retained rights that go back to before the treaty was reached. Now, Congress, controlled by the Republicans, may wish to embolden and allow tribes to manage forests and help the U.S. Forest Service and Bureau of Land Management do their job, which apparently they're not doing very well, by entering into agreements with these agencies. But the question that remains is, what else is behind this? How do they entice tribes to want to help protect national forest and rangelands other than to prevent harm to their own? Well, they have to incentivize them by not diminishing their treaty rights and by invoking magic words like federal trust responsibility to tribes, which is a nebulous term that encompasses very many things, many of which are not defined. And these provisions would allow the tribes incidentally, when they help manage the forests, to exercise off-reservation rights. There is nothing in the legislation thus far that would prevent that from happening. The legislation says something obvious. It says that entering into such a contract would not basically give the tribes possession or title to the land. Okay, well that's an easy thing to conclude because they don't own the land, the reservation lands anyway. It's held in trust for them by the federal government. They occupy those lands. They use those lands, but they don't own them. So what does that mean? It's an empty assurance. And I'll use the language that's in the statute, because what they do is they create a fiction. They create a fiction that treats federal land as Indian forest land for purposes of forest stewardship. But they say that this shall not be construed to designate the federal forest land as Indian forest lands for any other purpose. Okay, and they claim that that's a catch-all phrase which covers everything. But at one and the same time, they always express respect for tribal sovereignty, the government-to-government relationship, which they call as unique and special, and how tribes have retained and reserved treaty rights off reservation. Those things don't square with one another. They contradict one another. And there's no way you can prevent legislation from enabling a tribe to do this unless you expressly state this has no bearing and does not permit the exercise of retained or reserved treaty rights, aboriginal rights, or ancestral rights. That has to be explicitly included in the legislation, but they won't do it. They say, well, we can trust the agencies to guard the door. Well, we have found express evidence that the agencies are not going to do that. And that includes the Bureau of Indian Affairs, the Bureau of Land Management, and the U.S. Forest Service, which is from the Department of Agriculture. The other two are from the Department of Interior. We have express policies and guidelines and manuals from these agencies that state that they are promoting tribal, reserved, and retained aboriginal and ancestral rights found in treaties. Now, we had spoken with two of Montana's congressional representatives, staff members. One is Senator Steve Gaines' staff, his legislative director, in Washington, D.C., and we have spoken with them on the phone several times. We've also, in the D.C. meeting, met with the legislative director of Congressman Zinke's staff. And they're all apprised about our concerns, and they've asked us to help them rewrite the statute to address our concerns. But one of the problems is that when you start delving into the statute, you start looking and finding references to other statutes, which contain similar language. So if you're defining a term by a term defined in another statute, then you can't reference those other statutes if that term has a problem, provides a problem for you. One of the other statutes they're talking about is the Tribal Forest Protection Act of 2004. Now that statute, luckily, hasn't been implemented very well. There aren't many sewage contracts pursuant to that statute, because the process of getting the U.S. Forest Service to approve of the stewardship contracts is a very slow and cumbersome process. So one would think, okay, well, that's not a problem statute. Yes, but it has problem language, because in evaluating whether the service should enter into a forest stewardship contract, among the most important factors is the cultural, traditional, and historical affiliation of the tribe with the land subject to the proposed contract, the treaty rights or other reserved rights of the tribe relating to the land subject to the proposed contract. That is the same subject that I'm talking about in Senate Bill 2012. That would have to be stripped, and you couldn't even refer to that statute anymore. Okay. Another statute they refer to is the National Indian Forest Resources Management Act. Now, again, you have problems with that because that statute refers to the Indian Self-Determination Act, which is the main federal statute for promoting tribal sovereignty. And that means unaccountability to the federal, state, and local governments. By respecting tribal sovereignty, you are basically saying that you respect the right of the tribe not to respect the United States Constitution.
Exactly.
And they don't respect the Constitution, and their tribal members suffer from that, but the press in a politically correct world of Barack Obama and Hillary Clinton will not address that point. Now, S-2012, going back to the energy bill, uses language that talks about, well, what land should we look for to determine whether this contract should go forward? Well, if the forest land is located within or mostly within a geographic area that presents a feature or involves circumstances principally relevant to that Indian tribe, such as federal forest land ceded to the United States by treaty, federal forest land within the boundaries of a current or former reservation. That means tribes that have reservations stripped out from them previously, they're eligible. Okay, or federal forest land adjudicated to be a tribal homeland. That's where the courts start legislating from the bench, and they determine there to be a homeland. Now, the if, okay, that was just part of the definition. So when you start getting into treaty rights, and you start getting into homelands, and you start getting into former reservation, and you start getting into reserved rights, you're talking about the nebulous area of aboriginal ancestral rights. And that is basically the rights the tribes had before the United States was settled by the Europeans.
Larry,
Yes.
might I jump in? I'm sorry to interrupt you, but I want to jump in on because this treaty rights thing is part of the big scam of this bill. And the reason I say that is that most of the treaties were executed out here in the western states in 1855. Congress stopped executing treaties with Indian tribes in 1871. And those treaty rights for tribes off reservation were merely for hunting, fishing, and gathering, and on their ceded lands that they were paid for. They could continue to go on those ceded lands that now belong to the United States or states, and they could hunt and fish and gather. They had no jurisdiction whatsoever. The thing about treaty rights is that most of them, if not all of them, went away in 1934. when we now have 567 tribes who gave up their treaty rights to become federally recognized Indian Reorganization Act tribes. They could not be both. They could not be a treaty tribe and an Indian Reorganization Act tribe, which gave them many more financial benefits. What's happening under this administration is the illegal and politically smooth resurrection of treaty rights, which were gone in 1934.
Elaine,
yeah?
let me refer to a May 7th, 2015 memorandum from the U.S. Department of Interior's Bureau of Indian Affairs, addressed to all regional directions. Attention, forestry and wildland fire management, from the director, the acting director of the Bureau of Indian Affairs. Subject matter: reserve treaty rights, lands national implementation.
Yeah.
This memorandum establishes BIA policy for the new reserved treaty rights land program, and will apply to all. It will apply to all wildland fire management programs receiving such program funding. Purpose: get this, and I'll quote this. This is all quoted.
Yeah.
Ancestral rights associated with non-trust, non-reservation land, that's non-reservation land, is of critical importance to many American Indians and Alaska Natives across the United States. Beginning in fiscal year 2015, wildland fire management funding was appropriated for the purpose of treating and restoring tribal priority landscapes within and adjacent to ancestral and reserved treaty right land.
Yes. That's how they did what they had no authority to do. And that's part of this resurrection of treaty rights.
Right. Now I'll give you, and here's another document. Fiscal year 2015 Bureau of Indian Affairs Reserved Treaty Rights Land Plan. And I'm reading this quote unquote, and I'll be pleased to share the documents after the show. Beginning in fiscal year 2015, fuels management funding has been appropriated for the purpose of treating and restoring tribal land within and adjacent to reserved treaty rights lands. As stated in the fiscal year 2015 Wildland Fire Management Budget Justification, treaties with Native American tribes establish a unique set of rights, benefits, and conditions for tribes. Like other treaty obligations of the United States, Indian treaties are considered to be the supreme law of the land and are the foundation upon which federal Indian law and federal Indian trust relationships are based. Now, within various processes utilized to establish tribal and Native organizations' relationships with the U.S. government, retention of ancestral rights remains a common recognized connection. Examples include, but are not limited to, religious and cultural use, hunting, fishing, and gathering. For many tribes, the reserve right areas fall under the management of the federal agencies, and in some cases, tribes co-share management rights with federal agencies. The Department's Reserve Treaty Right Lands Program enables tribes to participate in collaborative projects with non-tribal landowners to enhance the health and resiliency of priority tribal natural resources at high risk for wildland fire. Okay? It says the intent.
You know, guys, this is obviously so much more because it does tie in directly with the Indigenous Peoples Treaty, which is a UN document.
Yep.
And none of these things have been ratified by Congress, in my understanding, have they?
No, Dan, this is interesting because I wanted to shift shortly to the U.S. Forest Service because I remember our conversations with the representatives of Senator Daines' office, and they had expressed a preference for dealing and using language that would only require dealing with U.S. Forest Service rather than the Department of Interior, because everyone knows the Department of Interior is not an honest broker. Because the U.S. Forest Service guidelines that we've located talk about exactly what you just mentioned. Okay, and they speak about how the Forest Service will implement the Tribal Forest Protection Act with that troubling language. okay? And the goal here is obviously to promote tribal sovereignty. And and these are new guidelines. That one set of guidelines came out at the end of the Bush administration in October of 2008, when all that craziness started to occur with the stock market, and the other one just came out this year. These are all new guidelines.
Mm-hmm. Yeah, and they expand the role of tribal government, and therefore, as the so-called federal controller, I guess you'd call the in trust, the federal government ends up taking an awful lot of our constitutionally guaranteed rights on off-reservation lands, and all of a sudden those constitutional guarantees go away. Am I correct?
It's one of those creeping encroachments, Dan. It's so small. Yes, I'm sorry, Elaine.
I'm sorry, I'm interrupting again, but I would like to jump in because just in today's Federal Register, October 12th, where this is being taped October 12th, in the October 12th Federal Register, there is a new proposed rulemaking for the forestry management plan that includes the tribal forestry management plan. These folks this is such a done deal that they have gone ahead starting today to get the proposed rulemaking in place to enact this bill. And in this morning's Missoulian newspaper, there's such a conglomeration of separate groups with different but harmonious goals. In this morning's newspaper, the headline above the fold, University of Montana may receive a $24 million donation, and the money will go to two programs, forestry, conservation, and the Global Leadership Initiative. Dan, this bill, this energy bill, is strongly tied in to the Indigenous Peoples Movement, to Agenda 21, to Congress globalizing and federalizing the states, and to the expansion of lands no longer under control of the states and that deprive the landowners and towns and counties that are in these reservations and off these reservations to deny them that jurisdiction that properly belongs to the states. This is a congressional movement to globalize our country. This is part of it. Mm-hmm. It really is. And it's been going on for years. And now the universities are getting funded. And the other sneaky thing is that this massive 792-page bill shows one sponsor, but there's 363 amendments put in by hundreds of senators and congressmen who are hiding.
Well, hold on. And one of those hiding is Mr. Ryan Zinke.
Absolutely.
But interesting,
Dan. Part of our conversation, and I've sat in on a couple of these conversations with Senator Daines' office, and I truly believe that he is trying to separate the sheep and the goats. And there was a conversation with Darren Thacker, who is Senator Daines' chief of staff, and we had a conversation, it's been 2 weeks ago now, discussing some of the concerns that the people in the Flathead area had with this bill. I was asked to sit in on that conversation. And my comment, and I think you guys would support this, my comment toward the very end of the conversation was to Senator Daines' staff, guys, understand one thing. We were told in 1993, after the UN Sustainability Treaty was approved, it was approved and signed by President George Herbert Walker Bush, and then brought to the United States. It never was ratified by treaty as required by law. In fact, it failed miserably as a result of the maps and so forth that were shown by Dr. Kaufman and Kay Bailey Hutchison, who was a senator at that time. And so anyway, we've got all these so-called soft laws, and the UN Agenda 21 program, and sustainability is one of those soft laws. They say, well, don't worry about it. We will protect, we'll make sure that we won't do anything that's not constitutional, and it's a soft law, so you don't need to worry about it. Well, guess what? Bill Clinton enacted virtually all of it through his sustainability initiative through all the various departments in the cabinet, at all levels of the cabinet, administrative and executive level. And then now we've got literally around our country, we've got all these things being enacted that are 100% Agenda 21. And guess what? In spite of the fact it was soft law, all of a sudden it's imbued in every aspect of our lives in this country. And I warned them to take a good hard look at the Indigenous Peoples Treaty, because it's the same thing. They'll say, well, it's not been approved by the Senate as required under treaties, but guess what? Everything will be enacted through administrative agencies, and next thing you know, we'll have all this stuff in place that are taking away every one of our civil liberties.
Right.
And anyway, that was my comment to them, and I do believe that Senator Daines is concerned about this, but we need to make sure that Ryan Zinke's office gets the point here too.
Well, we need to make sure that it isn't just Montana legislators. This affects all of the western states. It affects every state that has a national forest. And I certainly agree and would hope that Senator Daines would help rethink or remove this until there's at least National Environmental Policy Act review of the social and environmental and economic impacts to the states. They're completely circumventing NEPA, and until there's been some regional hearings taking the American public's input on this, and not just tribal government, this piece of the legislation in the Energy Act, this tribal forestry management piece, has 95 related amendments attached to it. So even pulling it out means we have to keep watching many other bills. Mm-hmm. And we've got what I thought was a do-nothing Congress has been extremely busy expanding tribal jurisdiction over state and national lands off their reservations as fast as they can. And it's dead wrong.
One of the things that I'd say about that, too, and you mentioned 2% of the population being actually tribal members, but in fact, living on a reservation, it's less than 1%, isn't it?
Well, in Montana, 6% of the population of Montana are Native, marked their census as Native Americans. That doesn't mean they're all enrolled, but it's 2% Indian in Idaho and maybe Oregon, and about 2% in Washington State. But we elect these senators and congressmen to represent 100% of the people in their states. And 95 to 98% of the American public is always ignored as this tribal expansion rolls out. It's been going on under this present administration. It's been going on many decades before, but it is on steroids under the present administration, and it is to diminish state sovereignty, state authority, citizen rights, constitutional rights. It's to start the regionalizing that the American Planning Association is moving forward with, the sustainability that Larry was talking about and you were talking about. It's to soften up this country, become part of the Agenda 2030 movement. And it's being done by the people we elect in Congress.
Dan,
no wonder we have such a serious and sensitive election coming up. No wonder.
Yeah. Dan, to make reference to your reference to the UN Indigenous Rights Treaty, again, and making reference to the representatives from Senator Daines' office, you can't rely on any federal agency to guard the door. The U.S. Forest Service has already been compromised.
Yes.
The manual that I'm going to read an excerpt from right now will prove this. one of the objectives of the Forest Service is to ensure that its employees, quote unquote, fulfill federal treaty obligations and uphold the federal trust responsibility to protect the rights and interests of Indian tribes. Ensure that Forest Service officials, programs, and activities respect tribal self-governance and sovereignty and honor tribal rights and interests. And also support the aspirations of the UN Declaration on the Rights of Indigenous Peoples. It explicitly has it in their manual. As of March of 2016, this manual has been changed to incorporate a whole new large section on this.
Yep.
Again, another section. They have section 1563.8b, Treaty Rights and Federal Trust Responsibility. Indian tribes reserve separate isolated reservation lands under the treaties and sometimes retain certain rights to hunt, fish, graze, and gather on the land ceded to the United States. These rights retained on ceded lands are known as, quote unquote, off-reservation treaty rights, close quote, or open quote, other reserve rights. Okay? Many treaties involve ceded lands that are within the boundaries of present-day National Forest System lands. The Forest Service shall administer lands subject to off-reservation treaty rights in a manner that protects Indian tribes' rights and interests in the resources reserved under the treaty. Indian treaty rights are property rights held by sovereign Indian tribes who signed the treaties. These sovereign property rights can only be extinguished by an express and unequivocal act of Congress. Okay?
What an outright lie. What an outright lie.
The point here is, it is an outright lie. It is a taking. It is a planned, choreographed, well thought out, considered taking slowly of national lands and ceding them back to tribes. And they can do it through contracts over time. Okay? If you have Indians in the southeast that no longer have reservations, they can be given contracts, and then if they have some tie to an ancestral homeland, which many of them do, because there have been adjudications or recognitions by federal agencies, they can have lands back. Now, you know that federal agencies have the right under executive order to obtain, to take federal land on behalf of and in trust for federally recognized tribes. This is done all the time.
Sure.
Yeah, but it's an outright, Larry, it's an outright lie because all of the treaties, particularly the Stevens treaties and the Indian treaties, gave them protected areas, gave them beneficial use and occupancy of a reservation. They had no jurisdiction or property rights in those treaties. They had none.
Originally, you're right on this, and that's true. I agree with you. But over time, through this incrementalism, they basically, through executive pronouncements and actual practice by agencies, have shifted the goal line.
They have.
Right.
Okay, and especially in the Ninth Circuit, okay, which covers the Northern Rockies, the Northwest, especially the Pacific Northwest, where the Stevens treaties are, with all this special language. There are approximately 60 tribes that have these reserve rights. 60 out of 567. So not all areas of the country will be affected equally.
Well, and the tribes demand that all tribes be treated equally now, so it will be all 567 anywhere near a national forest.
They will they will try to establish some type of parity of treatment here.
This is not just a revising of history, this is an intentional reversing of history in the Western states, an illegal intentional reversing of history, and it is all fraud. It is all wrong, unconstitutional and wrong. The problem is we have governors, we have attorneys general, we have state legislators in all these states who truly act and make decisions as though tribal sovereignty is superior to state sovereignty, and it absolutely is not. So the state are really literally slitting their own wrists by cooperating with this, by subjecting or submitting state authority to tribal authority. It's just frightening what's happening in the western states now. And one more point. This is one of the last federal agencies to fall in line. The Federal Highways and Commission, the Federal Highways Administration, put in the Indian Reservation Roads program years ago, throwing millions of dollars out to tribes for Indian reservation roads. Those roads are public roads, built by public tax dollars, and even in the treaties were required to allow settlers to use the public roads. So they're throwing millions of dollars out for Indian reservation roads programs that are public roads. There are no Indian reservation roads, and that doesn't matter. They're just throwing money out to the tribes, and those tribes take that money and do not give a dime to towns or counties who do have the authority and the responsibility for maintaining the road. So what's happening is among the 29 federal agencies, they're all being used to promote this expansion of tribal government, tribal jurisdiction over lands on and off reservation. Can you imagine what this bill is going to do to ski resorts across the country and recreation and tourism and hunting and the economies of these states? It's just, I just don't know how these senators or congressmen can look themselves in the eye. It's so wrong.
Well, one of the things too, guys, that you've alluded to repeatedly is that their our elected officials' number one responsibility is to uphold, protect, and defend the U.S. Constitution, and if they're state agencies or state officials, to uphold the state constitutions. And frankly, all these treaties and all these things that are not ratified under our requirements of our U.S. Constitution, they're treating them like they're more important than our constitutional rights. And the reality is it's time for Congress, especially, and also for state legislators, to realize that they're responsible to protect and defend the Constitution. And they need to get back to that basic reality.
Yeah, and the argument that they're facing repeatedly is, well, these tribes pre-exist the Constitution, therefore they're not subject to it, and therefore you can't do anything about it.
Anything that pre-exists the Constitution is unconstitutional, period.
That's right.
That's the other propaganda put out that our elected officials are swallowing.
But there's also another aspect here. This tribal forest management is being couched in a larger frame of mind where the forests are burning, we need to do something, and we need to do it quickly or there'll be more burned forests. And therefore, since the Tribal Forest Protection Act isn't working, because there's only 6 contracts in the last 12 years, we need to streamline the process and make it easier for these tribes to self-govern. Now, there was a recent article in the Wall Street Journal talking about how you have to let free market principles reign and let the tribes do what they need to do and get the agencies out of their way. Now, can you imagine ceding that kind of authority to these tribes? Do you remember, Dan, a year ago when we had found research showing that bipartisan legislation was enacted in 2012 allowing tribes to lease reservation lands without agency oversight? Do you remember? Right. We were worried about how, and you know what country actually lobbied for that legislation? Turkey. The government of Turkey. Yeah. The Islamic Republic of Turkey. Okay?
Well, this tribe and many others here are already engaged with Turkey and Saudi Arabia in a very big way. Same thing goes for the Canadian reserves up in Canada, working with the Palestinians and Iranians. You know,
but the point is, if you start streamlining legislation because the agencies are slow, that means you're giving more self-governance to the tribes who already have no political accountability to anybody. You don't know what's going on there. They have no legal obligation to account to anybody. It's only when they want money from Congress that they ever come forth with any information.
And page 459 of this Senate Bill 2012 addresses project streamlining. It just says, go for it, tribes. And there's also 2 simultaneous sources of big money to fund all this and incentivize the tribes. one coming from the Department of Interior, one coming from the Department of Ag. And a single tribe can apply to both for double the money and go after a national forest, and then benefit from the project streamlining. It's just disgusting what's in this legislation.
Now, Elaine, you brought up Section 809 of the bill, which is the Bureau of Land Management Resource Management Plan, and it deals with Eastern Oregon or actually Western Oregon, and it's important because I represented clients in the Klamath Basin.
Yes.
And what we found out recently in 2 filings that we made with state agencies in Oregon, because of a fraudulent recall election seeking to recall 3 of the 5 members of the Klamath Irrigation District Board of Directors. We found evidence of a program that they had well hidden for several years. It's the Farm Leaseback Program. It's a way that the federal government, the Bureau of Reclamation and Land Management, could buy out people's farms and ranches in areas where they wanted to conserve water for fish and tribal rights. And basically, only in good hydrological years, where there's plenty of water coming from the mountains and the watersheds, would farmers be allowed to lease back the lands they once sold, after getting cash in hand, to then cultivate and harvest crops. In dry hydrological years, they would idle, and they get paid some minimal stipend to idle. That seems to be a blueprint for a larger effort in the Northwest and West to idle lands and move people out from the rural areas and into the more urban areas.
Well, that's part of the act.
I think there's no question about that, Larry, that that is happening, and I think some of the articles that I've seen recently kind of attest to that fact. But one of the things that I want our elected officials to get on board with the idea, they need to do a lot more research into these various agencies and part of the already codified law that allows these tribes to have additional powers that are really not supposed to be there. And they need to get on board with the idea that it's time to end this nonsense of white guilt and constantly trying to find a victim for every single circumstance, and realize that we're all on this planet together, and we need to make sure that we protect private property and property rights for Native Americans as well as for other individuals. And the only way to do that is to uphold our Constitution.
Right, Dan, how do tribal members that live on a reservation and that have status because of the Indian Reorganization Act, how do the tribal councils, how are they permitted to deny those tribal members full U.S. constitutional rights based on sovereignty of the tribe? Are they saying that you can treat people less than American citizens if they're American citizens merely because they're a member of a tribe? They treat refugees from Syria better than that.
That's
exactly
true.
They give them driver's license and allow them to vote the Democratic Party. They bring them into havens, and you can't find them again. But they're going to cast their ballot on November 7th for Hillary Clinton.
Mm-hmm.
That's right.
But tribal members don't have those rights.
They don't have constitutional rights. They don't have civil rights. They don't even have parental rights. Congress gave tribal governments the parental rights of tribal members, and that's used as a punishing tool when members disagree with their tribal government. These tribal members cannot even speak up for the peril that and the squalor that they live in on these reservations, at risk of some kind of retribution from their tribal government. They're just used as numbers for more money to the tribal government. And they're full U.S. citizens off the reservation, but they cannot speak for themselves. That's one thing I try to do everywhere I can. I have a number of tribal friends across the country that keep me informed on what's going on these reservations, and it is it's like worse than Cuba. It's just horrific. There's a new book out that's taking a real whipping from the Indian industry, and that's Naomi Schaefer Riley's book called The New Trail of Tears. She's right on target. She's a journalist for the New York Post and very highly respected. And she visited numerous reservations that confirm what I'm saying here. And I, too, have visited 17 reservations and did the Going to Pieces book based on these issues. Tribal members are suffering under this system badly, but a few tribal leaders and many congressional leaders and governors and state legislators are profiting from this. They're profiting from things like $1 million for road money every year that they don't have to spend on roads. They can put it in paper sacks and give it to elected officials. The financial power of these tribal governments has controlled Congress now, has literally taken it over and controls Olympia, Helena, Boise, our capitals. The big money. That's why that's why Congress seems to have an allegiance to tribal governments over any duty it has to the state.
Well, it's a merry-go-round of money. The Congress appropriates, hundreds of millions, if not billions of dollars for the sake of tribes. Tribes then recirculate that money in the congressional economy by contributing to campaigns and to special dinners and other events on behalf of the congressmen. That way they get their favorite policies.
I've offered many times to appear before congressional committees or to meet with senators or congressmen and to talk about these things. And the money and political correctness is just so powerful. Not one of them wants to hear from people like me that have done the homework and the research and that care deeply about Native Americans. It's all about the money. And now it's all about taking down the states.
Well, I think right now, Elaine and Larry, I think it's time that our elected officials listen to folks like you that have done the research and done the investigation into this. And incidentally, I had a report from Indian Country, TodayMediaNetwork.com, where they said the U.S. support for American Indians is somewhere in the neighborhood of $20 billion a year.
It's probably greater than that now. But it's I think it's more akin to the national defense budget. We're talking 567 separate governments that get millions every year. And then they get it from their state. State of Montana throws huge state taxpayer dollars out to these tribes when no state has a fiscal duty to a tribe unless it self-imposes one. So Washington, Oregon, Idaho, Montana, they've all set up their own state trust relationship with tribes. So these tribes are now double dipping.
Dan, if you're $20 billion,
part of the comment that you've made, Elaine, too, is that the reality is this money doesn't go to the individual tribal members. It goes to the tribal government, and God only knows where it goes from there.
Well, if it's
Congress and the state legislators.
Right, but if the $20 billion is a correct number, okay, assume that to be correct, then the $2 billion or so dollars that Senator John Tester's Tribal Water Compact bill calls for is 10% of that.
Yeah.
Just for the CSKT for 7,600 people. Yeah. And probably 7,500 of them won't see any money.
Right. Yeah. So what the listeners need to do is start doing some real noise making with every elected official at the state and federal level, and to do some homework and to start writing about this in letters to the editors, start educating your family and friends, because we either get our Constitution back and get a Congress that abides by the Constitution, or we have to change it. We have to get them out of office somehow, some way.
Right.
Well, the first step in that direction would be November 7th, voting not for Hillary Clinton.
Well, that certainly would help, but one of the things that we really need to focus on, if we're going to be effective on this, is to make sure that these private individuals, understand exactly what's going on in our country, and that we need to stop some of this stuff by not only contacting our legislators and or voting for or against the ones that really act outside of their legislative mandate, but we also need to educate people around the state and around the country on how deeply embedded these laws and these pieces of legislation and treaties and all these other things are becoming in our national fabric. And it's time that we wake up to this stuff. And with that, I'd like to give you guys an opportunity to talk about your Montana and Idaho tour to explain all this stuff to various folks in different areas. Would you like to discuss that trip that you've got planned?
There are a couple of groups that are bringing Mr. Kogan out to Washington, Idaho, and Montana for an 8-day tour, beginning the 13th, beginning
tomorrow.
Actually, beginning tomorrow, and going through the 21st. We will be in Spokane, Washington. We'll be in Coeur d'Alene, Idaho. We'll be in Kalispell, Eureka, on down to St. Ignatius and the Flathead Reservation area. We'll be going over to Bozeman and over to Billings and coming back to Missoula. We will be all over western Montana, the Idaho Panhandle, and eastern Washington with public presentations where Mr. Kogan will speak on these issues of the Tribal Forestry Management Act, this Energy Act of Senate Bill 2012, and many other things. But those are the two key pieces. And of course, the Salish Kootenai Water Compact, which is being modeled out and rolled out across the western states. So it's going to be a jam-packed tour covering 3 states, and we're grateful for Mr. Kogan's time. And Larry, do you want to add on to that?
Well, that is the primary reason we're coming out. We need to identify what these problems are for people. It's very complex. It's like a multi-layered onion, and that's why a lot of people can't find this stuff. We want to make it plain for them where they can look for these issues in an effort to push back against them. And we have to push back against them together as a team. Okay, that means people in Montana have to stick together even though they're from different communities. And they have to work with people from Idaho and people from Washington and people from Oregon and people from Nevada.
Yeah.
Okay, and Wyoming. Utah, to push these initiatives back, because these are the states that are being primarily targeted, okay, by the federal government. Another document I wanted to make reference to was a Forest Service has a natural resource guide, okay? And they even put their own language in italics for the Forest Service. Trust responsibilities are essentially those duties that relate to the reserve rights and privileges of federally recognized tribes, as found in treaties, executive orders, laws, and court decisions that apply to national forests and grasslands. Okay, that says it all. This is embedded in the agency bloodline.
Yeah,
and there's no way a legislator can excise this in legislation, because legislation ultimately must be implemented by a federal agency.
Yeah, and we need to do a house cleaning at the administrative agency level to clean out a lot of this codified law language that was never part of our legislative responsibilities, and it was never done as the way our founders intended, which is through Congress.
Well, ever since President Clinton took office, the obligation of the executive branch has no longer been to just faithfully implement the laws that Congress enacts. Their agencies make law.
Here's one of the reasons I am so proud of both the Sanders movement waking up the American public and the Trump movement waking up the American public, and why this election is so critical. That is because we have been, as a country, intentionally uninformed by our elected officials and ignored, and We are American people with a very good heart. We've been muzzled. We've been just strapped down by political correctness. It's very hard for any one of us, anywhere in this country, to stand up and say, I value and respect Native American culture along with all other cultures, you know. But I can't even speak on federal Indian policy without being slammed as a racist. We have to take the muzzles off of ourselves and talk about these decisions being made by our Congress. Tribal governments don't make these decisions. Our state legislators, our governors, our congressmen have done this to us, and it's their job to undo this right away.
Dan, in answer to your question, also part of the tour will be to focus on what opportunities there may be to challenge the CSKT Water Compact, which affects the western part of the state in a negative way. And what we found is that there is one federal contractor, Mr. Edward Sheets, employed by the Bureau of Reclamation, who has destroyed the Klamath Basin with his other federal contract with the Bureau of Reclamation, who is here in Montana working to help the state through your governor and your attorney general to implement the water compact before Congress even reviews and ratifies it. Okay, so it's being implemented on the ground. SB 262 is in the process of being implemented with the help of a federal agent.
It has been since April. The compact implementation technical team is chaired by Edward Sheets, who chairs the destruction going on in Klamath simultaneously. Same federal operative engaged by the state, by Governor Bullock, to pre-implement the compact, as Larry said, long before it's even ratified.
Now, it was Edward Sheets also that went with Dr. K to Idaho, wasn't it? That we found out?
Could be, yes.
Well,
trying to help them.
Guys, I hate to end this program when we're in such a good discussion, but I'm afraid we've reached the end of our program, and I need to remind our listeners to please join us next week for another Connecting the Dots radio program. And again, guys, where can our listeners go to a website or to a location where they can find out about your upcoming tour and locations and times and places so that they can be part of that program?
They can go to thiswestisourwest.com. They can send me an email. My email is Toppin, T as in Tom, O-P-P-I-N, Toppin@AOL.com. There are several groups in these areas that we'll be visiting that have websites too, and there's probably not time to name them all. But there's good word going out all around. Quickest way might be to give me a phone call. I don't mind. My phone's all over the internet, 509-949-8055, or email Toppin@AOL.com. And even on the road, I'll be able to respond to emails and phone calls as we're making this 8-day tour. So it's just important that the public turn out and the public take their muzzles off, do their homework, and speak up to their elected officials. It's time that we do this, or we're going to lose this country.
Well, I agree with that, and the thing is I think a lot of our elected officials may be thinking they're doing the right thing, but it's important, it behooves us that we make sure that they do the right thing. And embedding tribal policy and things like this in an energy bill so that they can get it slammed through without a lot of public oversight is not the way to make that happen. So with that said, ladies and gentlemen, I wish that you would join us again next week for another program on Connecting the Dots, and I want to thank our guests for being so forthright and giving us such good information, and please try to join them in their tour throughout Washington, Idaho, and Montana. So with that, turn the show back to you, Kelby. Thank you, and God bless.
Thank you, Dan and Public.
Thank you, Dan. Appreciate it.
Thank you, Dan. That's going to conclude the show for today at the Republic News Network. Ladies and gentlemen, we went a little bit long tonight. So God bless. Good night. We'll see you next Thursday, 6 p.m. Pacific. Bye-bye.